So we're going to talk about the Habendum clause today, which basically determines how long you get to hold on to that lease. And today we'll talk about the primary term, which is that initial period of time that the oil and gas company has to look for and start producing oil and gas. So the Habendum clause, sometimes it's called the term clause because it tells you the term for which you get to continue operating that lease. So it defines how long your rights last as an oil and gas company, and that primary term is basically how long it takes you have to drill that first well. And we'll see that there's some complications. You can sometimes say, well, I started, so that should be enough, or maybe the first time I didn't get oil, but I'm still working on it. We'll see lots of ways that that can be defined through the lease. But basically the primary term is how long you have to first hit an oil and gas well. The secondary term, which we'll talk about more in the next lesson, is how long you can keep the lease if it's producing. And typically it's as long as oil and gas is produced, but we'll see that there's a lot of litigation about what it means to say that well is still producing oil and gas. So the Habendum clause. Here's an example of a Habendum clause from your producer's 88 lease that I gave you. Subject to the other provisions herein contained, this lease shall be a term of blank years from this date, called the primary term, and as long thereafter as oil or gas or other mineral is produced from said land or land with which said land is pooled hereunder. So in other words, you see those two parts of the Habendum clause, or the term clause, which is one, the primary term, that term of blank years, maybe it's 3, maybe it's 5, where you have to first find oil, and then the secondary term, which is as long thereafter as oil and gas is produced. And we'll talk next time about what that means. So what are some of the big Habendum clause problems? Well, one is, how do you maintain that lease during the primary term? And we'll see it can be more complicated than you'd think. If you just read your lease, you might say, well, look, I've got 5 years to drill. So if, the first couple of years I don't do anything, no big deal. What we'll see is it's more complicated than that. Then the second big question is, can you keep it beyond the primary term? Generally, that's only if you've hit oil and gas or you're doing something that suggests you're about to. We'll talk about the different ways of doing it. The most normal way to do it is you hit an oil and gas well and it continues producing. When we talk about that next time, we're going to have to talk about what does it mean to have continued oil and gas production. What we'll see is that a lot of courts define that as paying quantities. So just because you have a trickle of oil and gas, most courts won't say that really is still being produced. You're going to need to show that you're producing in paying quantities. Okay, so the first complication that we have to talk about in terms of the primary term, that initial period of time to drill for oil, is the drilling delay rental clause. And you have to understand how this developed, which was that the courts, they weren't necessarily following the literal terms of the lease. In fact, they sort of made up some new terms that they basically said are necessary to protect those small landowners. And we've talked about it before, but the kind of animating concern of oil and gas law is those lazy oil and gas companies, they never want to come and produce oil and gas on my land. And the reason that is what we worry about is because for the landowner only makes money when oil and gas is being produced, because the landowner gets that royalty. It's true they get a bonus up front, but the most money they get is if there's oil and gas being produced. So landowners are often frustrated that the oil and gas company isn't acting quickly enough, particularly if they have a long primary term. Because if you gave that oil and gas company 5 years to look for oil, what if it just does nothing for 3 years? And courts weren't happy with that because they said, look, the landowner really wanted you to drill, and so they implied a duty to start looking for oil, duty of exploration, that would cut off the lease even if that primary term hadn't run. So that was an implied duty that wasn't really in the text and seems almost contrary to the text that gave you 5 years to drill. but the courts felt it was necessary to protect landowners. So what a drilling delay rental clause is it's a way of addressing that criticism from the courts. And it says, you know what? I am going to go ahead and drill I'm going to go ahead and pay you a rental if I don't drill. So if I haven't drilled and your complaint is, well, I haven't gotten anything yet and my primary term isn't over for 4 more years, so you could keep doing nothing, the oil and gas company will pay you a little bit of money in return for allowing the lease to continue. So even though the lease itself seems to say, hey, you could keep this for all 5 years, in fact, usually leases nowadays include a drilling delay rental clause that says, look, we don't have any obligation to drill in these first 5 years, but if we don't drill, we'll give you a little extra payment every year. Typically, it's not very much. It's nothing like what you'd get if the oil well came in. It's typically not as big as the bonus. So it's just a little money to say, look, we really mean it when we said we got 5 years to drill. We understand it's an inconvenience for you to have your land tied up with this lease, so we'll give you a little bit of money each year. Now, there's different kinds of rental clauses. One is an unless rental clause. What that means is you don't have any obligation as an oil and gas company to drill or pay. But if you don't pay and you don't drill, you just lose the lease. It's gone. So there's automatic termination if you don't have payment or drilling. All right, so let's talk about one of these unless clauses, and we'll do it using the Schwartzenberger versus Hunt case, which is from North Dakota, 1976, and can be found on page 228 of your book. So there was a lease taken in 1972, just 4 years before this gets to the Supreme Court. And what happened is the Hunt estate, which had the lease, paid the delay rentals for the first 2 years. Okay, so we know the courts are going to require you to do something if you haven't drilled every year. And the lease specifically said, in this case, we're just going to pay delay rentals if we don't drill. The Hunt estate paid the delay rentals. So what's the problem? Well, there was a mutual mistake between the parties, and so the payments were $8 short. Now you might think, okay, $8 short, no big deal, right? Give them the extra $8, go on your way. Well, as we see, it's more complicated because what kind of delay rental clause was this? This was an unless clause, which means unless the payment is made, the lease terminates. So here's a classic unless clause from the Texas Association of Petroleum Landmen, and or the American Association of Petroleum Landmen, this is their Texas Drilling Delay Rental Clause. It's that unless clause. Let me read it to you. If operations for drilling are not commenced on or before 1 year from the date hereof, so if you haven't drilled for a year, the lease shall terminate unless on or before such anniversary, lessee shall pay or tender to lessor or to the credit of lessor in a bank a certain number of dollars, herein called rentals, which shall cover the privilege of deferring commencement of drilling operations for a period of 12 months. Upon like payment annually, commencement of drilling operations may be further delayed for successive periods of 12 months each year during the primary term hereof. So, in other words, standard unless rental clause. It's going to terminate unless we pay you these drilling delay rentals. And we'll see that makes it very important that you correctly pay those rentals. So this is an unless clause. And the problem is that Hunt basically was negligent in its land work. And then, and at some point, it was notified by the landowner, and they said, wait a second, you owe us $8 more. And Hunt resisted that for 5 months. So they resisted paying that extra $8, $16 for 5 months. How did this happen? Well, effectively, the oil and gas company's landmen we talked about that American Association of Petroleum Landmen. A landman is somebody who goes out and finds good properties to lease and negotiates those leases for an oil company, or sometimes themselves, and ends up transferring that to an oil company. But basically, the problem here was that Schwartzenberger owned 406 net mineral acres in 419 gross acres. And the reason was they had 100% of the minerals in a quarter and 95% of minerals in the rest. The landmen wrongly assumed they had 95% of minerals in everything, and so there was an underpayment of rentals of less than $8. The court says, you know what, it's only $8, but the unless clause says if you don't make the payments correctly, we have automatic termination, and that's what happens here. So as you can see, there can be a really bad outcome if you pay those delay rentals wrong. And what I can promise you is that every company that has a bunch of leases has some with delay rentals, that use delay rentals, and they have very sophisticated systems to make sure they never make this kind of mistake. You don't want to lose a whole lease over $8. So how do you make sure that you've properly paid your delay rentals? Got to make sure it's on or before the due date. You send them early, and at least the amount provided for. Might err on the upside if you think it might be more. And remember, that's one reason why we use those in gross clauses, to make sure we have the number exactly right, even if the acreage is a little bit off. To the proper parties. Often we're going to have a bank designated so that if we can't reach them, we can find a way to pay that, to make sure we paid that delay rental. Finally, in a permitted manner, again, there'll be usually, you can mail it or you can send it to a bank. There'll be a couple different ways to make sure you don't miss that deadline and you get proper payment of delay rentals to extend your lease. Okay, now that seems a little bit harsh. We'll talk in a little bit about why you still might choose an unless clause, and people still do. But let's first talk about some of the other options. So one is an or rental clause. And the or rental clause is called that because it doesn't say that the lease will terminate unless you pay the rentals. Instead, it says either you have to drill or you have to pay. And so if you don't drill, you owe money, and you could be sued for that money in theory. They probably just, when you asked for the $8, they probably sent it to you. But it creates a legal obligation to pay. So you have to either drill or pay, but the lease is not going to terminate. Now, that's a covenant, not a condition or special limitation. A condition or special limitation is a condition on your continued ownership of the lease. This is just a promise to pay. And so if you fail in that promise to pay, the lessor can't terminate the lease. Instead, they just sue for the rentals plus some interest. Now, often that will also include a forfeiture clause that basically says, well, if you didn't drill and you didn't pay for a long period of time, or you're way out of you didn't come close or even try to pay, well, at some point you'll forfeit. But you won't forfeit because you messed up paying $8 for a few months. Okay, here's what an or forfeiture clause looks like. If any rental or royalty is not paid when due, the lessor shall notify the lessee, so the landowner will notify the oil and gas company, thereof in writing, and this lease shall not terminate unless the lessee fails to make such payment within 15 days after receipt of such written notice. Provided, however, that if there is a dispute as to the amount due and all the undisputed amounts are paid, the 15-day period shall be extended until 5 days after that dispute is settled by final court decree, arbitration, or agreement. The lessee fails to make such payment after receipt of such notice within such period, then this lease shall terminate as to the portions or portions thereof as to which lessee is in default. So in other words, see, there's still a forfeiture clause which says you gotta, once you're notified by your lessor, hey, you didn't pay me my delay rentals, you gotta send them in 15 days. Or if there's some dispute, pay what you know you owe and go ahead and litigate what is in dispute. So in this case, Hunt would have said, okay, well, yeah, we owe you everything but these $8. If we want to fight about these $8, we can go on and fight. All right. There are some other hybrid rental clauses. That can be an unless clause, but that has some savings language. So in Colorado's, the Colorado lease for the Apple, it's usually called Apple, the American Association of Petroleum Landmen, it says, or AAPL, if drilling operations are not commenced on or before a certain date, this lease shall terminate unless the lessee, so in other words, unless, right? So you have to make the payments. But if lessee shall in good faith and with reasonable diligence attempt to pay any rental, but fails to pay or incorrectly pays part of the rental, this lease shall not terminate unless they can rectify the error within 30 days after written notice of the failure. So there's a grace period attached to that unless clause. All right. Now, if that all seems like crazy complicated to deal with making these payments, there is an alternative that is increasingly common in modern leases, and that's a paid-up lease, which is you just make the payments in advance. You say, here's all the delay rentals I will ever owe you. I'm going to pay them to you when I take the lease, and then we're all paid up. I never have to worry about sending you delay rentals in the exact right amount on the exact right day. So it doesn't have a rental clause, and the rentals are paid up. So it says, this is what they look like. Typically, just like this does, they're just going to be all caps, paid up lease. This is a paid up lease in consideration of the down payment. Lessor agrees that lessee shall not be obligated, except as otherwise provided, to commence or continue any operations during the primary term or make payments during the primary term. So, obviously, this is much more convenient. Just make the payments up front. You won't lose a lease over $8. But what I want you to notice about this is this sort of modern solution, it really undercuts the whole reason for these delay rentals in the beginning, which is that, remember, the courts basically made up the need for a delay rental by saying just having the landowner getting a bonus isn't enough. The oil and gas company can't just wait till the end of its primary term to drill. It's going to have to drill within the first year. Otherwise, we're just going to terminate this lease. And the oil and gas company said, okay, no, we don't want that duty. Here's the deal. We'll just give you a payment every year that we don't drill. Okay, paid up lease completely removes that incentive because you've already paid all the rentals up front. In other words, you just paid bonus, and you always paid bonus. So what the paid up lease is, it gets rid of that incentive that delay rentals were supposed to create to drill. So I think the fact that the courts allow this is in some ways a retreat from the early days when they basically wanted to force oil and gas companies to drill earlier because they believed that oil and gas companies were just leaving things to the last second. Nowadays, if you have a paid up lease, you can leave things more or less to the last second, and we'll talk about some of the problems that arise from that. Before we do that, I did want to take 1 second. Let's go back to the unless clause. So we got the unless clause, which means that it terminates if you don't make the payment. Why would anybody sign that kind of lease? Why would an oil and gas company put its whole lease at risk for if it messed up some kind of payment? Well, let me describe a couple advantages. The big advantage is there's no obligation to do anything. So under an or lease where you have the obligation to drill or pay, let's say you think a lease is worthless and you forgot about it. Doesn't matter, every year you don't drill, you are incurring an obligation to pay those rentals. By contrast, if you really want to ghost a lease like that, i.e. just forget it, never get in touch with them, et cetera, with an unless clause, It's the perfect way to do it. You have to do nothing. If you forgot about a lease, it doesn't have any value to you. You have no obligations to that. The lease will just terminate automatically, and you never have to talk to each other again. So that is so that's an advantage. As we'll see in the course, there can also be monetary liability that attaches to companies that fail to produce oil and gas from a lease if that oil and gas gets taken away by your neighbors. If the lease terminates, that cuts that all off. So if you really have a lease that you care so little about that you can't even make the drilling delay rentals, well, maybe it's better to be out of that situation and not potentially subject to liability. So it's not completely crazy to have an unless clause, but I think most oil and gas companies nowadays would prefer a paid up lease, and basically we don't need this whole rigmarole. You gave us 5 years to drill, we'll drill within those 5 years. All right, so if you are going to drill by the end of the term, then the question is, have you drilled in time if you left it to the last second? And it's not too uncommon to leave it to the last second, because think about what oil and gas companies are doing. They have lots of different leases, and sometimes maybe they're drilling those leases ahead of schedule. But if they get piled up, there's a boom, they got too many that are expiring at the same time, they're going to try and keep as many of those leases as they can by drilling them all, just before, at least before they get done. So they're kind of racing from lease to lease, trying to produce them. And so sometimes, and if they have an extra 6 months on one, we'll leave it till 6 months. I got to get the ones that are expiring right now. So sometimes there can be a scramble at the end of the term. So for the oil and gas company to say that it has been drilling on the land, there has to be some activity on the land, or maybe it could be, adjacent land, that is directly related to or in preparation for actual drilling. So spudding, which is like actually the drill entering the ground, is not generally required. So, but what commencement is, hard to say. Sometimes it's defined in the lease what it specifically means. Maybe you need to have a drilling rig on site, or at least one under contract. It can depend on the particular case. So let's talk about Breaux versus Apache Oil Company Corporation. That's from Louisiana, 1970. There, the lessor says, lessee did not commence the well. So the lessor landowner says the lessee oil company didn't commence the well, didn't pay delay rentals, so lease is gone. Well, what does the lease require? It says it terminates unless on or before that date, the lessee commences operation for the drilling of a well on the land or acreage pooled therewith. So it has to commence operations for drilling of a well. Well, what does commencing operations mean? Let's talk a little bit about what you do when you drill a well. So you can see the well on the right. Basically, you have, the broadest is a conductor pipe that's going to go down, and you are protecting the groundwater. So basically allows the drilling to happen within an enclosed environment that will protect that groundwater. So groundwater will keep dirt out of the hole. That's your largest pipe. Then you have surface casing inside. That's drilled to isolate the groundwater zone. So depth for that is typically state regulated. Usually you have to go at least 100 feet below the base of the groundwater. Often when you're drilling through groundwater, you're going to have to use, sort of more natural, just water only drilling fluids, etc. So those are the steps that you're using to take groundwater protection. Those are the early steps in drilling a well. Now, if you want to know what a drill looks like, you can go to the Breaux Museum. They got a good one. You had pictures in your book, but I just wanted to kind of show you what this looks like. So you see how this drill, it basically has these grinders on it that grind up the rock. And then what happens is that you have mud that is pumped down and carries the pieces of rock to the surface. And so basically, you read in your book, in one of the very first readings, about how the discovery of drilling mud really transformed the oil industry. Because until that point, they couldn't drill into the ground because basically the gravel would build up where it the drill had chewed up the rock and it would stop the drill. But by pumping mud down, you're able to push that rock up to the surface where the rock can be removed. All right, so what actually happened in that case? Had drilling operations commenced? Well, basically, all the company had done was built the board road and a turnaround road. Needed that to drill, but does that mean drilling operations had commenced? It was facts disputed about whether the drilling equipment was actually present. So the only thing that could be relied on for summary judgment was the board road and turnaround road. Drilling happens 4 days after the date of expiration, and court says building the road is enough, actual drilling is not required. All right, some states have different constructions of what it means to commence operations. So in Montana, for example, you have to spud. So in other words, you have to actually start drilling. In Kansas, you don't need to spud, but you have to be engaged in activity on the surface, and the lessee has to have a drilling rig available, which means either they own it or they have one under contract already. Because they're saying, well, look, just because you built the road, if you don't even have the drilling equipment, how do we know you really this is intentional? What if you just drove your pickup truck and threw a couple 2x4s down on the ground and said, oh, it's the start of a board road? That's not going to be enough. So the question, it's sometimes a gray area, but the question is how clear is it that they really were going to drill at the time the lease would have expired? All right, last complication that I'll note, just by reference to this Outer Continental Shelf lease that the US uses. And one thing you'll see is that the US, when it leases oil and gas, they look a lot like just regular oil and gas leases that a farmer would use in Texas. So it definitely grows out of those leases. But they make provisions that are increasingly common in leases, which is that you don't necessarily need to have drilling on the surface if you are drilling from a neighboring property into that land horizontally. So this is this directional drilling provision. Directional well drilled under the leased area from a surface location on nearby land not covered by this lease shall be deemed to have the same effect for all purposes of the lease as a well drilled from a surface location on the leased area. Drilling shall be considered to have been commenced on the leased area when drilling is commenced on the nearby land for the purpose of directional drilling under the leased area. So in other words, in that Lightning versus Anadarko scenario, let's say you're trying to drill into this land, but you're doing it over from the land on B. As soon as you start down there, you are now, for purposes of the lease, have commenced drilling on A, even if it's going to take you a little longer to drill over onto A's